let the law clerks in and let IT know we can begin to broadcast. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1376, Hemp Industries Association and RE Botanicals, Inc. petitioners versus Drug Enforcement Administration and Ann Milgram, Administrator, Drug Enforcement Administration. Mr. Pennington for the petitioners, Ms. Carroll for the respondents.
Mr. Pennington, good morning.
Morning.
Please proceed.
May it please the court. Shane Pennington for petitioners Hemp Industries Association and RE Botanicals, Inc. Your Honors, I'd like to spend the time that I have today primarily starting with standing and then moving to try to clarify what may be some confusion about the primary substantive points that petitioners challenge with respect to DEA's interim final rule. Beginning with standing, the Hemp Industries Association, I think a good place to start is with the 2004 Ninth Circuit case, Hemp Industries Association versus—
Counsel, I'd rather you start with a specific reference to what it is about the regulation that bothers you and why it hurts you.
Sure, Your Honor. So,
well, in all due respect, that's standing as far as I'm concerned.
Yes, I agree.
right, absolutely, Your Honors. So if you go to the newly promulgated regulation that's at issue from the interim final rule, it says it addresses tetrahydrocannabinols naturally contained in the plant cannabis sativa L. Those natural tetrahydrocannabinols are a substance that every hemp company inevitably handles or interacts with.
Counsel, please just focus on the language and tell me why the language bothers you.
So the language is the definition of natural tetrahydrocannabinols at 21 CFR 1308.11 D31. And DEA's regulation defines that term tetrahydrocannabinols to include tetrahydrocannabinols naturally contained in the cannabis plant. And the reason that is harmful to the hemp industry and to every hemp company is because every hemp company inevitably and necessarily handles natural tetrahydrocannabinols.
And we know that from the record because—
Well, you know it from the record. I mean, if you look at the petition for review, you'll see that RE Botanicals and 300 some companies that are members of Hemp Industries Association are manufacturers and processors of hemp, and hemp is parts or all of the cannabis plant.
Yeah, but please focus on the language. You're saying the regulation differs from the statute?
Yes, Your Honor. So
in other words, you're not challenging the statute.
No, Your Honor.
You're challenging the regulation, arguing the regulation is different from the statute.
Yes.
Where is it different and why does that hurt you?
So the statute excludes from this reference to Schedule 1 tetrahydrocannabinols in hemp. The statute refers to tetrahydrocannabinols in hemp.
As opposed to defined as hemp.
Yes, Your Honor. And that difference really matters because all natural tetrahydrocannabinols occur in hemp, but not all of them meet the definition of hemp. And so, for example, take Delta-9 tetrahydrocannabinol. Delta-9 tetrahydrocannabinol occurs in hemp, quite obviously, because that's the material that determines whether whether a cannabis material falls on one side of the line or other between hemp and marijuana.
If the government were to say that we do not interpret the regulation any differently than the statute, then there'd be no controversy, would there be?
Not with respect to that claim, Your Honor. That's right.
That's the only claim you're making.
No, Your Honor. The other claim that we're making is that DEA's failure to explain its change of position with respect to its obligation under 21 USC 811 D1 to subject Epidiolex to Schedule 5 controls.
Why is Epidiolex of any concern to you?
Because as the government explains in its brief, DEA apparently views Epidiolex as hemp, and we are the Hemp Industries Association. And if Epidiolex is a material that DEA views itself as compelled to subject to control under 811 D1 to ensure treaty compliance, then presumably it would also view the rest of hemp as requiring the same level of control. And the government,
well, if the government were to deny that, then there's still no controversy, right?
if the government were to deny it, but in footnote 10 of the government's brief, the government doesn't deny it. It in fact says,
we'll see what the government says about that. But
yes,
anyway,
Your Honor.
but certainly on the first point, just as my colleague Judge Rogers pointed out, there'd be no standing if the government did not take a different position than you with respect to the interpretation of the regulation vis-a-vis the statute. If the government took the position the regulation is no different than the statute, then there'd be no controversy over that issue.
I want to agree, but there's just one problem, and that's just Chenery, because the interim final rule is what's at issue here. And the interim final rule certainly doesn't track the statute. The regulation that's in the Code of Federal Regulations is not the same as the statute. And so whatever the government says in this case doesn't change the fact that when anyone, including local law enforcement regulators, go to look to federal law, which they do, to determine what's criminal and what's not at state law, for example.
No, if the government were to say we had never intended any interpretation different than the statute, they would be bound by that in the future. So
they would be bound in the case of an enforcement action. Of course, we don't have to wait for an enforcement of an unlawful regulation in order to have standing to challenge. And
no, it's not. If the government takes a position that the language in the regulation means the same as the statute, that there wouldn't be any controversy in the case at all. But we'll see what the government says.
Yes, Your Honor. I would like
Mr. Pennington, just so I'm clear, to follow up on Judge Silberman's point, the statute talks about hemp. The regulation defines hemp and concludes that only this Hypernex meets the test. Is that your point?
I'm not sure that I understand the question, Your Honor. Could you please repeat it?
Well, I thought your argument was there's a statute that refers to hemp and authorities the government has. And then the agency comes along and issues a regulation which defines certain statutory terms. And in so defining those terms, it has, in your view, created this problem.
That's right, Your Honor.
All right. So when you read the plain text of the statute, and then you look at the plain text of the regulation, your position is, regardless of what the government may say now, what it has promulgated in the interim final rule is simply either inconsistent with the statute or it has to revise its rule.
Precisely
In other words,
right.
Your point is, since the government has taken the position not only in the interim rule and confirmed it, as it were, in its brief, for counsel to make a concession to us only goes so far, in the sense that unless counsel tells us the commission has specifically authorized this concession, I'm not clear what it's worth.
I completely agree, Your Honor. And if I could emphasize, the court has held in, we cite this case in our brief, it's Americans for Safe Access versus DEA. It's a 2013 case. And in that case, the court recognized that when DEA puts a substance in Schedule 1 of the Controlled Substances Act, that is a, quote, inherently pejorative classification that the government means and intends and knows will influence third-party regulators and lawmakers. And it does. And we cited cases in our brief where that has in fact happened both before and after the 2018 Farm Bill and the interim final rule. And the point there is that this, whatever they might say in this case, Your Honor, it has already caused us harm, reputational harm, by making this authoritative and inherently pejorative statement about a substance that we use. To give an example, it would be like a cake company, for example. And if DEA were to say that flour and eggs were Schedule 1 controlled substances, that would, to say that the
Wait a minute,
industry-
counsel, I don't know what you're talking about. The whole burden of your case is that the term in hemp is somehow broader than defined as hemp.
That's right. That's right, Your Honor.
And that is your whole case, right there. And on looking at it, it doesn't look to me to be intended to be any different. But, and I took from the government's brief, but there was no intention to make a difference here. If there is no difference, then there's no case.
If I could explain the difference, I think you've put your finger directly on, the very important point with respect to this claim. And so
Mr. Pennington, while you're answering that question, would you point to the specific sentence in the rule that you think conflicts with the statute? The only one I can find is on the last sentence on the left-hand column in the Federal Register at 51-641. Is that what you're depending on when they say a cannabis derivative extract or product that exceeds the THC limit is a Schedule 1 controlled substance, even if the plant is less than the 0.3% THC? Is that what you're relying on?
No, Your Honor. I would point on the same page, 51-641, on the third column in a section titled "Removal of Schedule 5 Control over FDA-Approved Products." And I know that.
Well, that's the Epidiolex.
Yes, Your Honor, but they give an example there that I think illustrates the point well. So if you'll hear me out here, it's in the last paragraph there that begins with note, quote, "Note that CBD in a mixture with a Delta-9 THC concentration greater than 0.3% by dry weight is not exempted from the definition of marijuana or tetrahydrocannabinols." That means that the natural tetrahydrocannabinols in hemp are not just marijuana. This example, it would be marijuana, and I don't dispute that. But the point here is that it's also natural tetrahydrocannabinols, according to DEA in the interim final rule. And that is unlawful. The reason, and it has consequences for this industry, because the sentencing under 21 USC 841, the sentences that are applicable to tetrahydrocannabinols versus marijuana differ greatly. And
you're diverting from the key point. Your key language difference is in hemp versus defined as hemp, right?
Yes, Your Honor.
Okay. Now tell me why the term defined as hemp is somehow more restrictive than in hemp.
Because
for you, and having, what is the injury to you because of that difference?
Because Delta-9 tetrahydrocannabinol is always 100% Delta-9 tetrahydrocannabinol by definition. But in order for that substance to be hemp under the statute, it would have to be not more than 0.3% Delta-9 tetrahydrocannabinol. And that's impossible. That's impossible. So the effect of DEA's rule is to reimpose the 0.3% threshold on to the tetrahydrocannabinols definition, which is something that Congress did not do and couldn't have meant to do. And so,
Are you sure you're not challenging the statute?
yes, Your Honor, because the definition of tetrahydrocannabinols in the 2018 Farm Bill was a codification of HIA-VDEA2. In that case, the Ninth Circuit explained and held unequivocally that natural tetrahydrocannabinols are not Schedule 1 tetrahydrocannabinols. And
I think that may be a broader statement than the Ninth Circuit said. In my recollection, the Ninth Circuit said that the material that came out of parts of the plant that were not defined as marijuana could not be reached indirectly through the definition of THC.
yes, Your Honor. And in natural tetrahydrocannabinols, I see that my time's up. Could I answer?
Go ahead.
Thank you, Your Honor. HIA-VDEA2 you did say the holding correctly. The point though is that every natural tetrahydrocannabinol is contained naturally in hemp. Therefore, by excluding tetrahydrocannabinols in hemp, Congress necessarily excluded all natural tetrahydrocannabinols.
Counsel,
That's
I'm
the
still
point.
trying to, forgive me, my colleagues would just let me ask this one question. I'm still trying to figure out why the language difference that you focused on has an impact on you. What is it that in hemp allows you to do that definition of hemp does not?
The way that it affects us is that we are, by necessity, every hemp company is handling natural delta-9 tetrahydrocannabinol. And when you look at natural delta-9 tetrahydrocannabinol, everyone agrees that if it's not from an excluded part of the cannabis plant, it is marijuana. There's no dispute about that. But because it could be coming from an exempted part.
You're still not linking it up to the language change that you're focusing. You're missing that. Why are you missing that? What is it about the language difference that causes you a problem?
Because
language difference, not general policy. What about the language?
The difference between tetrahydrocannabinols in hemp and tetrahydrocannabinols that meet the definition of hemp is that delta-9 would have to be 0.3% of itself in order to meet the definition of hemp, and that's impossible. Therefore,
and you somehow think that the term in hemp allows you to, in the processing, go above 0.3%.
There's a question whether any particular natural delta-9 might be qualify as marijuana, but it cannot qualify as natural tetrahydrocannabinols. That's our point. And so you're correct that we do believe that in processing, if the natural delta-9 level were to spike slightly above, the 0.3% threshold somewhere in the process, which.
And you think Congress intended something different from in hemp from the definition of hemp?
Absolutely, Your Honor, or they would have said definition of hemp. They could have said that. That's not what they said. And they also didn't indicate any.
You're giving a pretty broad meaning to the term in hemp. But I think I understand what you're saying. But in order to understand your case, you really have to read the facts of the other case to understand what it is. Your concern is the processing of the product. You would temporarily go over 0.3%, or the residual would be perhaps over 0.3%. And you're worried about an enforcement proceeding against you in that event. Is that correct?
Thank you, Your Honor. That is one concern that we have. But even apart from that concern, if natural delta-9 tetrahydrocannabinol is a Schedule 1 substance, as the IFR says it is, because it cannot meet the definition of hemp, then other third-party regulators can enforce against my clients and hemp companies across the country, not because they're handling marijuana, but because, according to DEA, they're handling natural tetrahydrocannabinols. So it imposes a double layer of criminalization of something that is an essential part of this industry, and that is unlawful.
We'll see when the government has a chance to respond.
Thank you, Your Honor.
All right, Judge Rogers, do you have any questions?
Not now. Thank you.
All right, we'll give you a couple of minutes and reply, Mr. Pennington. Ms. Carroll, good morning.
Good morning. Thank you, Your Honor. May it please the court, Sarah Carroll on behalf of the government. As the court is aware, in the Farm Bill, Congress removed substances that it defined as hemp from the CSA schedules, and the rule under review merely does the same to DEA's list of controlled substances.
Counsel, please come to the core issue. What about counsel's argument that the regulation, by using the term defined as hemp, is more restrictive than the term in hemp? True or not true?
Well, the fundamental problem with that argument is that petitioners did not make it in their opening brief. If you look at their opening brief, they do not mention this.
You're absolutely right about that. You're absolutely right. I was going to ask that question of counsel, but let's assume it was implied in the opening brief. And I'm not sure, I think you may be right that they did not make the argument, but let's assume it was implied. What's your answer?
My answer would be, I mean, it's difficult for me to give too much of an answer because we didn't have an opportunity to brief it, but my answer would be, I think as you were noting, Judge Silberman, the point of this rule is simply to conform DEA's regulations to the statute. DEA was not doing anything other than what the statute does, and DEA did not.
In other words, your position is, you're saying to the court openly, committing the agency, that the regulation is not intended to have any different meaning than the statute.
Yes, I am saying that. I think it's possible that Mr. Pennington might think that the statute means something different than potentially DEA would have thought the statute meant if it had an opportunity to brief this issue. I'm not sure. It's a little hard for me to understand their point. They seem to be saying, if you have a substance that is hemp because it's low in THC, there is still a problem because if you somehow ignored the other parts of the substance and only looked at the THC, of course, the THC would be 100% THC. And I'm not sure I completely understand that. I also don't understand how it is relevant to them because they have submitted no evidence whatsoever of their activities or any injury. I mean, this court has made clear time and again that petitioners challenging agency action have the burden of demonstrating their standing through evidence. They have the same burden of production as a plaintiff moving for summary judgment in district court. But here there is no evidence whatsoever on these seemingly, I think, pretty nuanced, to say the least, distinctions that petitioners try to draw in their reply brief. But certainly they have not carried their burden of showing that there is some difference between the statute and the rule that would cause a concrete injury to them.
Ms. Carroll, let's leave the Epidiolex alone and go back to the left-hand column, last sentence on page 51, 641. Would you tell me how the agency reads that sentence? As a result, a cannabis derivative extract or product that exceeds the 0.3 percentage THC limit is a Schedule I controlled substance, even if the plant from which it was derived is not, or is under the 0.3%. What does the agency say that means? Forget the Epidiolex.
Right. Thank you, Your Honor. So forgetting about Epidiolex, that means that in DEA's view under the statute, if someone takes a cannabis plant that itself would qualify as hemp because it's very low in THC, but then creates some kind of derivative from that plant, and the derivative itself is higher in THC, the derivative is controlled as marijuana, even though it's from a hemp plant.
All right, now let me ask you this. The only thing, and this comes from the second case, that exceeds the 0.3 is this WHM and IHM, which would have to be considered a derivative, an extract, or a product. And it's simply part of the process, isn't it, of making the hemp?
That is what they say in the other case, Judge Henderson, but they are very adamant in the other case that they are not raising that claim in their challenge to the rule. They certainly could have raised that claim in the challenge to the rule. You know, Mr. Pennington could be here right now saying that language in the rule is wrong and that matters to us because we handle IHM and WHM as they call it, and that inflicts an injury on us. And if they had raised that issue in their challenge, in their direct challenge to the rule, we would have addressed it and responded to it. But instead, in the second case, you know, on page 60 of their opening brief in that case, they say that they think this court would lack jurisdiction to consider that argument in this case.
You're confusing me, referring to this case and that case. Which case?
Sorry, Your Honor.
Yeah, I lost you.
So Judge Henderson was asking about the status of intermediate and waste hemp material under the rule. And I was saying that in this case, the petition for review challenging the rule, petitioners have not raised that argument. In their second case, which is the appeal from Judge Boasberg's decision, they are very adamant that they are raising that issue there and that they are not raising it in their petition for review. And indeed, they say that
yes, you're absolutely right. I just was lost between this case and that case.
I'm sorry, Your Honor. Yes, that was not the most precise language. So I'm sorry for being confusing. But Judge Henderson, I think, you know, you raise an issue that petitioners could have chosen to litigate in their petition for review of the rule, whether for strategic reasons or, you know, I guess I can't say why they've chosen to litigate these cases the way that they have, but they chose not to make that argument in their petition for review.
All right, well, let me ask you then what the agency considers a derivative extract or product that would exceed the THC limit. What did you have in mind with that sentence?
I think I'm not sure I can say much more than what the sentence means, but these days it's very common for companies and for different people to make, you know, oils and things that can, you know, beverages, food, all kinds of things that contain substances taken from the cannabis plant. They're not, you know, the cannabis plant itself, but it's some kind of oil or serum, or there are all kinds of different things. And DEA was saying that if a substance like that is created from a cannabis plant, but the substance itself is high in THC, the substance does not qualify as hemp and is subject to regulation under the CSA.
So you're not, is the agency's reading of that sentence as excluding hemp?
I'm sorry, Your Honor, is the agency's reading that excludes hemp?
You're not talking about hemp in that sentence.
Right. We're talking about things that are too high in THC to qualify as hemp. DEA, of course, recognizes that Congress removed hemp from CSA control.
And I would like to go back to the summary of your position with respect to petitioner's main argument, which is the language of the regulation differs from the statute in a way that hurts us. And your response is, number one, that argument was not made in the opening brief and therefore is forfeited before us. That's your major, and the government has never had an opportunity to respond to that specific point, which is the key point in their argument as they present it here today. Secondly, even if it was legitimately before us, you're stating unequivocally that the regulation is not to be interpreted as any different than the statute.
Yes, that's right. All DEA was doing was conforming its regulations to the statute.
Even though the language is slightly different.
Right. Of course, this court has said time and again that an interpretive rule doesn't have to use the exact same language as a statute, and that's all that we have here.
No, but okay, but you did not, there's no intention to broaden your power in the statute, in the regulation vis-a-vis the statute.
That That's right. I want to be careful because it's possible that Mr. Pennington's interpretation of the statute would be different than DEA's interpretation of the statute. So I do not want to.
Well,
say
he's not challenging the statute. He's making very clear that he's only challenging the regulation, not the statute. And the premise of his whole position is the regulation is different from the statute and it hurts him. You make a number of points. Number one, he doesn't ever indicate in why it hurts him in his opening brief, and he never even makes this argument in his opening brief.
Right.
But even if it were made in his opening brief, your statement is the regulation is not, and this commits the agency, is not intended to have any different meaning than the statute.
Yes, that's right, Your Honor.
Okay.
I'm happy to answer any other questions that the court might have. But
Judge Rogers? Judge Rogers, do you have any
Oh,
questions?
no, thank you. I just thought you were saying something different. Thanks.
Okay. And Judge Silberman?
No, I'll be interested to hear a reply from.
All right. All right. Thank you, Ms. Carroll.
thank you.
Mr. Pennington, why don't you take a couple minutes?
Thank you, Your Honor. The government did not concede that natural tetrahydrocannabinols are not Schedule 1 tetrahydrocannabinols.
That is not the question before us. The question before us is simply, is the regulation, did you challenge in the opening brief the difference between the regulation linguistically and the statute?
Yes, Your Honor.
Counsel said you did not make that argument, which is you've now said today was your key argument. If you did not make it in the opening brief, how can we allow you to make it in a reply brief?
I'm not saying that you should allow me to make an argument for the first time in the reply brief. If you look at page 46 of petitioner's corrected opening brief, you'll see that there we say, on their face, the 2018 Farm Bill's amendments reduce DEA's regulatory authority. We point specifically to the amendment removing hemp.
Counsel, that does not say that the regulation is different from the statute, and therefore we are hurt by the difference in the language of the regulation.
Your Honor, we did,
which is your core argument today.
but we repeatedly say that the regulation violates the statute because it purports to schedule natural tetrahydrocannabinols, which is
Counsel,
the point.
it does not refer to the language. It is not a textual argument.
It is,
You
Your
know,
Honor.
the Supreme Court said we're all textualists now.
I want you to be a textualist, Your Honor. There's a difference between tetrahydrocannabinols in hemp and tetrahydrocannabinols that meet the definition of hemp. Natural tetrahydrocannabinols, to meet the definition of hemp, would have to be less than 0.3% of a particular natural
Counsel, you did not
tetrahydrocannabinol.
make the argument in opening brief focusing on the difference in the language. You did not make that argument.
Your Honor, I respectfully, I believe that we did. It is, the argument
Let's
is,
assume arguendo you made it. What do you say when the government says, wait a minute, the language may be slightly different. The government does not assert. The government asserts that the language of the regulation is exactly the same meaning as the statute. Then there's no controversy.
if that's what the interim final rule said, we would agree. But the interim final rule,
Well, they interpret their own regulations. So if they say that we do not interpret this regulation any differently than the statute, then there's no controversy, right?
no, Your Honor, because the CSA is a statute that this court has recognized third-party regulators rely on to understand what is criminal behavior in this country.
But counsel, if the government says we do not interpret the regulation as giving us any broader authority than the statute, they mean the same thing. And
Your Honor, the
certainly
problem is,
you can piece the language through and say it means the same. But when they say it means the same, you're not vulnerable.
if they said that in the actual regulation, I would agree with you. The problem is that, a state lawmaker or a sheriff's office is not going to go look.
Well, then you'd
at
have a
this
case
law.
against the sheriff. That's not before us.
That's true, Your Honor. But when you can tell that the government's authoritative position is going to subject my clients to harsher criminal
That
penalties.
is not, that is baloney.
But Your Honor,
That is
respectfully,
absolute baloney.
it's. Could I respond to Judge Silberman's question, Your Honor?
You mean you say it's salami rather than baloney?
Yes, go ahead.
So we've cited cases, Your Honor, in our briefing where courts, federal courts, have relied on DEA's purported subjection of natural tetrahydrocannabinols to Schedule I control to subject people to harsher criminal penalties than they would have otherwise been subjected to. We pointed to 841 of 21 USC section 841, which treats marijuana and tetrahydrocannabinols very differently in terms of the penalties that are involved. There is just simply no question that by subjecting natural tetrahydrocannabinols to Schedule I controls, DEA has opened the hemp industry to harsher criminal sanctions than Congress intended them to be open to. And that is an Article 3 injury that should...
Because some sheriff in Nevada would interpret it. Is that your point?
Not just some sheriff in Nevada, Your Honor. Drug screening at federal government workplaces now looks for natural tetrahydrocannabinols to tell whether people can get jobs because they believe that the natural tetrahydrocannabinol...
You're assuming, I give up.
All right, Judge Rogers, do you have any questions?
No, thank you.
All right, then Madam Clerk, if you would call the next case.
Will that mute?
Case number 21-5111, Hemp Industries Association and Ray Botanicals, Inc., appellants versus Drug Enforcement Administration and Ann Milgram in her official capacity as Administrator of the United States Drug Enforcement Administration. Mr. Zorn for the appellants, Ms. Carroll for the appellates.
Mr. Zorn, good morning, and please proceed.
Good morning, may it please the court. My name is Matthew Zorn. I represent Hemp Industries Association, and I'm arguing here on behalf of RE Botanicals. I'd actually like to take my points out of order and maybe address something in my case, but it overlaps with the prior case. And it's actually the case or controversy issue. I think the court had this concern about what it is the difference between the statute and the rule. And I would like to very quickly address that. I think what's going on in the prior case, and frankly, why there's a case or controversy in my case, is the agency does not agree with the Ninth Circuit's opinion. When it says it's just following the statute, what it's really saying is it's following its interpretation of the statute, which is different from what the Ninth Circuit held in the first and second.
The Ninth Circuit is a different case. And I don't understand why we even have to consider it. Because you still haven't. Do you want to argue the last case now?
No, I don't, but it's why there's a case or controversy here, because there is this long running.
Let's turn to your case for a moment.
Okay.
I would like to focus on your case at this point. What action by the agency causes you injury?
There have been remarks by the agency that we cited in our complaint.
Remarks?
Yes, by an agency.
What's the remark?
It was a remark in, I believe it was a month before the rule that came out where
you're deliberately not challenging the rule in your case.
We are not. It is a declaratory judgment action.
Wait a minute, just let me finish. You're not challenging the rule. Then I'm asking you, what action did the government take that causes you injury?
It's not an agency action case.
Even a declaratory judgment, you have to have some injury. Okay,
yes.
Now what is the action the government has taken?
The government has taken.
You said there was a speech by an agency official. What speech are you referring to? Are you talking about the speech saying we always enforce the law? That's the speech you're talking about?
That is one of them.
That's ridiculous. That's ridiculous. What does that have to do with your case? The government says they always enforce the law.
Well, it was more than always enforce the law. And that's why I started with this. There's been this long running history between the hemp industry.
I don't
and
want to know
DEA.
about a long running history. I'm just a simple bald headed old judge. Tell me where your injury is that causes you to seek declaratory judgment.
If the DEA is asserting that it is regulating the intermediate hemp material.
Now you're going back to the regulation. What action was taken against you? It's not the regulation. What action was taken against you that gives you injury?
The regulation is part of that.
The speech by an agency official indicating they'll enforce the law. Anything else? Anything
Respectfully, the regulation is why there is an injury. However, it is not the
Now you're
subject
back to
of-
challenging the regulation.
We are not, because the regulation is what gives rise to a case or controversy on the issue of whether intermediate and waste hemp material. That's not addressed in the rule, but the rule shows that this agency thinks it still has authority over the production of hemp.
Are you saying the injury that you face that allows you to go to district court and declaratory judgment is based on the government's position and the regulation?
Yes, it's based on what they're doing in the regulation.
Counsel, that's ridiculous. That means you challenge the regulation.
It does not mean challenging.
I don't know what you're talking about.
We are.
If it's not, if there, would you concede then there's nothing else that you're complaining about to go seek a declaratory judgment other than the regulation?
We are seeking a declaratory judgment that we are authorized or immune from the agency.
Counsel, I'm asking for your injury. What is it that causes you? Forget APA. Under declaratory judgment law, you have to have something you can point to that indicates there's a controversy.
The agency is saying that we need to register with the DEA to make hemp products because during that
Where
process,
do they say that?
They have said that, frankly, in the litigation itself.
Which litigation?
The one we're talking about now. That's what they've said. They said that.
Said what?
That we would have to go to the agency to register to make hemp products because
what statement? Where are you pointing in your brief to the statement which gives rise to this injury?
Because what, Your Honor, what they're saying is
the because is not an answer. Where is it you show in your brief the indication that there is an injury allowing you to get a declaratory judgment?
The entire premise of intermediate and waste hemp material being a controlled substance means that if we make that, then unless there is an authorization or immunity to make that during the hemp production process.
You want an advisory opinion, don't you?
We don't want an advisory opinion, but how else are we supposed to? Otherwise, what they're saying is we need to go and register to the agency. And in the First Circuit case we cited, that court stated very clearly that we shouldn't have to go submit a registration to DEA to figure out.
Who has told you what you have to do?
The agency has said you have to register because this is a controlled substance.
Register for what?
For a Schedule I license, which is clearly not what Congress intended in this situation. And so we're stuck in a situation, respectfully, under
what statement? Show me what page in your brief where you indicate where your injury is traced to.
Well, respectfully, standing hasn't been contested in our case.
Yeah, well, I'm contesting it.
Okay, well,
judges are obliged to look at standing on their own, right? And I don't see your standing.
Well, I would say our standing is they're saying that intermediate and waste hemp material are controlled substances. We submitted a declaration in the court below, which
they are saying it where?
That's what the rule is saying. It's saying
now you're challenging the rule,
right? But the rule could be correct on this point. In other words, the rule could be correct that intermediate and waste hemp material are Schedule I controlled substances. But our claim is that even if those are controlled substances, we do not have to register with DEA because when Congress said that the USDA has the exclusive authority to regulate the production of hemp, those products are part of the production of hemp. And that was the claim that we brought below. And respectfully, the district court judge erroneously interpreted our claim to challenge the rule. what you're talking about, Your Honor, maybe that's even correct, but that is not the basis that the district court judge dismissed the case below. And that's what we're contesting now, which is we said we weren't challenging the rule, and he said we were challenging the rule.
In
You
effect,
certainly just
you
sat-
were. That's what I think Judge Silberman's questions are trying to get at. In other words, some prospective injury down the road is not enough at this point.
Right, but we're being injured right now because we can't get, for instance, our banking, and this is in the declaration that we submitted below. I mean, this has banking implications. So we are suffering injury from this right now.
What's the banking injury? You
Well,
can't get a loan?
Yeah, banks do not finance companies that work with controlled substances.
All right.
So it really does matter for us right now. And I'm already into my rebuttal time. So
I know, but one of the problems obviously in these two cases is
Sure.
counsel may have wonderful theories. Counsel may even have some substance to the theories, but that's not our role here. And we're not going to give an advisory opinion. The agency has, even in its rules, said it's simply implementing the Farm Act.
well, respectfully, it's not, but
Well, that's what it says, all right, in the interim rule. And at this point, that's stuck with it. And if you do get charged or your registration application is denied, then you may have a different case, but you just don't present it to us. We have nothing to grab a hold of.
But the problem with your question, Your Honor, is you're saying if our registration application is denied, what we're saying is we should not have to file a registration.
I know that. Well, people say they don't owe taxes either. And you know, Congress is very clear, pay your taxes and then come in for a refund. In any event, I'm not suggesting the statutes are precisely analogous, but under Article 3, our jurisdiction is limited. That's the problem.
Well, there have been
Nobody wants to face here.
There have been two courts of appeals, Your Honor. There's been the Eighth Circuit and there's been the First Circuit presented with similar circumstances.
I know, and we all know that some circuits may not be as rigorous in enforcing Article 3 requirements as this circuit, based
Sure.
on our interpretation of Supreme Court requirements of what Article 3 requires. I mean, that's the reality we're facing, all right? And neither counsel seems to want to help us on that. You may win down the road, but it's too early for us to get there.
Well, Your Honor, if this court comes to a different conclusion from those circuits, then obviously it's free to do so. But there have been two other courts that have weighed in similar circumstances.
No, I'm saying those circuits tend not to enforce Article 3 as rigorously on occasion as this circuit. That's a known fact among counsel who practice in this circuit. And to come and say to us, our standing is self-evident is not enough.
We put in a declaration below, so there is evidence in this record that there is standing to.
What does your declaration say specifically?
It mentions the banking. It mentions that our clients.
It says we tried to get a loan and we couldn't get it.
Then you've got a challenge to the bank. Then you've got a case against the bank.
That's the declaration also talks about how our members use and process these materials, and that we don't want to go to DEA for registration. And under MedImmune,
Counsel, do you have, let me try one more time. Do you have any specific action of DEA that you wish to rely on as an injury entitling you to a declaratory judgment?
We do not have an enforcement action, but under the Supreme Court's precedent in MedImmune, I believe that it would be inconsistent for this court to hold that we need to wait for the DEA to bring a criminal action against.
Wait a minute, have they indicated that they would bring a criminal action?
They have not indicated that, but again, I don't think we need.
Then you really want an advisory opinion long before there's a controversy.
We would like a declaratory judgment consistent with the Supreme Court's decision in MedImmune.
All right, thank you.
All right, Ms. Carroll, good morning again.
Good morning again. May it please the court, Sarah Carroll again. As I think the court was just noting, if plaintiffs here are not challenging the rule, they are challenging nothing in particular and are just seeking an advisory opinion about what the law means, and that plainly is off limits. We have contested both standing and ripeness, and they would not satisfy either one. But as I believe the discussion with Mr. Zorn highlighted, Judge Boasberg was also completely correct to recognize that what plaintiffs are trying to do here really is challenge the rule. If they're challenging anything at all, it is the rule. And that is clear from the complaint, the amended complaint, which is replete with claims that the rule represents an overreach by DEA. It's clear from the fact that they filed this suit just a few weeks, I shouldn't say a few weeks, several weeks, something like 8 weeks after the rule was issued, sought to hold their petition for review of the rule in abeyance while they litigated this suit, told the district court that they might dismiss the petition for review if they won this suit. And Mr. Zorn today, began his argument by talking about the rule, and I think conceded that if I understand him correctly, that the rule is the basis for their standing in this case. They can't circumvent Section 877's exclusive review provision by trying to challenge the rule that he is relying on as the basis for injury through a declaratory judgment action or something like that.
What do you think about his reference to the other circuit cases?
The other circuit cases are different from this case. In the First Circuit case, New Hampshire Hemp, Section 877 was not litigated. So that case simply didn't present the issue that is presented here. And in Monts, in the Eighth Circuit case.
What about standing in both those cases?
In both cases, the plaintiffs were found to have standing. I believe in the First Circuit case, DEA had testified at a state legislature hearing and said definitively, this activity that the plaintiffs want to engage in is illegal. And the Eighth Circuit, I believe I think in the First Circuit, there was also a published Federal Register ruling saying that.
That's what I recall.
Legal. Yes.
That's what I recall.
Right. And in the Eighth Circuit, there was something similarly definitive. Again, plaintiffs here could have raised this argument that they're trying to make here in their challenge to the rule, and we could have talked about whether they had standing in that context. But what they can't do is try to get around Section 877 by seeking a declaratory judgment in the district court on this claim about the rule's validity. I'm happy.
Suppose you had said, your agency had said that the practice that he's concerned about would be blatantly illegal, even once 0.3 is reached at some point in the process, it is in marijuana, or the residual at the end of the process, if it's excess of 0.3, it's marijuana and we're going to enforce it. Would he then have jurisdiction in the district court?
I'm not sure that he would. I think if they had said that in the rule, of course, he would have to.
No, I'm not talking about the rule.
Pretending there was no rule. I think then you would probably get into
put aside the rule. If the government had squarely said we're going to enforce, if there's at any point in the process 0.3 more in excess of 0.3 of THC appears, it's illegal as marijuana. Or if the residual at the end of the process is more than 0.3, we're going to enforce. Would he have standing in the district court?
I think it would be, I'm not sure exactly how it would come out, especially under this circuit's case law, because this circuit has said in cases like Seegers and Ord that you need some sort of individualized threat against the plaintiff. It's not enough if there is just a law.
You're right. Let's just, so if you had said the hemp industries does this, they're in violation, is that sufficient?
I'm reluctant to say definitively. That sounds more like what was at issue in cases like Seegers and Ord, but certainly that bears no resemblance to what we have here. And this case also is just very different because the statements that they're relying on are in a rule that is subject to the Court of Appeals exclusive jurisdiction.
Well, they also refer to the statement that you're going to enforce the law.
Right, but I don't think anyone, they certainly don't cite any authority for the proposition that that would suffice under this court's case law or really any other courts.
Any other court in the United States for that matter. No, I agree.
So taking your point, even were the circuits to be as rigorous about Article 3 as we are, there was a factual basis.
Exactly.
Yes, there certainly was.
Nothing like that here. And counsel have yet to point to anything like that here. And that's our difficulty, it seems to me.
Yes, I agree, Your Honor, especially if we sort of take them at their word that the court should ignore the rule and put the rule aside. There is nothing at all like that here. Happy to answer any other questions that the court might have. Otherwise,
Right, it doesn't look like there are. So thank you, Ms. Carroll.
Thank you, Your Honor.
Mr. Zorn, if you can respond to Ms. Carroll's argument, but please don't go back and forth with the ground we've already covered.
I will not, Your Honor, and I actually just have one point to make.
Okay.
It's very simple. We've heard from the government that we're challenging the rule. There's nowhere in this rule does it mention intermediate hemp material and waste hemp material. Our claim in this case is that Congress impliedly repealed that. If what the government is saying now today, that its rule reimposed those restrictions on IHM and WHM, my colleague's case is an easy case because they didn't do notice and comment, and then it would be a legislative rule, and then the rule should be thrown out. And that's why we didn't challenge IHM and WHM in the rule, because it's not mentioned in the rule. But if they are saying now today, if that is what they are arguing to this court, that that's what the rule did and we should have challenged the rule, then this agency has promulgated a legislative rule without notice and comment and other procedural issues we've identified. And this agency should not be allowed to bypass notice and comment to create rules that have criminal implications. Our claim in this case is that Congress impliedly repealed, and what they're saying is their rule went over the top and put that back in. And that's why we brought the claim in the district court. But if what they're saying today is that this rule does all the things it says it's doing, then this court should not stand idly by while the agency slips in a legislative rule under notice and comment. Thank you.
All right. Thank you. Madam Clerk, if you'd give us an adjournment.
Honorable Court is now adjourned until Wednesday, April 20th at 9:30 a.m.